Hi, I'm Rob Stein, one of the partners here at Lazega Johanson. One of the specialized areas that I head up for our firm is our zoning team. We work with boards of directors on rezonings, variances, and other governmental issues. Recently, a board member from one of our community associations reached out to me after seeing those big rezoning signs posted near their community, and we jumped into action. In this case, the developer was seeking to rezone some farmland to allow for 250 cluster homes. We quickly obtained the full rezoning application materials from the county. We set up and met with the county planning official who was reviewing the application, and we also set up a meeting with the developer. At that meeting, the board and I began some negotiations to try and obtain some reasonable protections for the homes in the community. Unfortunately, we were not able to make any real progress with these developer negotiations. So, with the first public hearing about to come up, we had the board send out an e-blast to all the owners to ask that they attend the upcoming Planning Commission meeting. At that hearing, we presented our side to the Planning Commission, and we had 150 homeowners right behind us, all wearing red shirts as we had asked them to do. And after that initial hearing, all of a sudden we were able to work out a deal with the developer that provided for fewer homes, a large tree-filled buffer, and a fence to be built along the property line. The lesson is that there is power in numbers. Community association boards of directors have recognized that they are in the best position to lead a rezoning fight that impacts the entire community, and that they have the ability to connect and bring together the membership of the association to support that fight. Sometimes the board will ask me whether they have the authority to get involved and whether they have the authority to spend association funds on rezoning legal work. Essentially, the answer is probably yes. Georgia law is very supportive and flexible. The Georgia Nonprofit Corporation Code, which is the law that governs all community associations, allows community associations to be involved with any lawful activity, unless the association's own legal documents somehow limit them. Both the Georgia Condominium Act and the Georgia Property Owners Association Act provide the board with wide-ranging powers to take care of association issues that arise, and this includes rezoning issues. Finally, most association declarations and bylaws also give the board broad powers. And most association documents don't restrict the board's authority to move money inside the budget from one line item to another. Not to worry about that. I've looked at many association documents over the years, and frankly, I've yet to see a set that limited a community association board from being able to be involved in a rezoning. Many boards see that their involvement on rezonings is critical because the changes that are often being requested are dramatic, and because if the board doesn't get involved, property values and quality of life for the community will suffer.